Welcome to National Lien and Bond, mechaniclean.com's seminar today. I think we're going to have a very good turnout and an exciting program. I'd like to introduce Anatoly Nurshberg, who's with the Chicago Home Builders Association, and let's get started.
Hi, this is Anatoly. I'm with the National Association of Home Builders, namely the Chicagoland chapter. Today we'll be talking to Hal Immelfarb, the founder of National Lien and Bond, as well as Mechanics Lien. He's been in the mechanics lien industry for the better part of the last 30 years and has assembled a nationwide network of attorneys to help contractors and subcontractors with their lien rights. Today we'll be talking about how construction execs can reduce credit and legal risk by securing job receivables on every job. If anybody has any questions, we will have Q&A throughout the webinar today, so please post them on the Q&A or the chat session, and I'll be sure to keep an eye on that and ask Hal as we go along. Hal, take it away.
All right, Anatoly, thank you very much. I'd like to suggest that if you can, we have approximately 70 to 75 attendees this afternoon, so we know who's on the audience a little bit and get familiar with everyone, because this is kind of like an open flat platform. We'll at least try to interact with the audience. Everybody's here. So if you can let us know what kind of company you are, and if you have questions on what kind of areas you want to speak about, because I like to address a lot of these issues. So what I'm going to do today is go in between talking to you here on the screen and then showing a PowerPoint of some of the topics and continue the conversation. I'd like this to be a great program and be very informative. And I'm sure we'll have people with different levels. One thing I want to say to everybody in the construction industry, as Anatoly mentioned, I've been doing this work for many years, and I've been having the great honor and pleasure of working with lawyers and notice services and clients nationwide and recently even globally. My first case I ever had basically was a situation where steel came here from Luxembourg and it was shipped through Chicago, where I'm located, and it went to Wisconsin. And my client received a call from the general contractor at the federal military base, the Army base up in Wisconsin, and said, "Hey, you guys are 6 months late. You owe me $1 million. The $300,000 I ordered for steel, forget about it." So my client asked me, "What can we do?" And I said, "Well, as I recall in law school, we can use the Uniform Commercial Code that first says, I'm nervous, I'm insecure, and I'm not going to deliver my steel to you." And so I called up the general contractor and said, "Listen, sir, you ask for the steel to be shipped to you in an American boat. And in the boat, it had to be like an American charter. There's not many of them. It took us 6 months to find it. We complied with the spec. So basically, your steel is coming in 2 days. It'll be sitting in the Chicago docks from Luxembourg. And no, you can't have it. And it's going to incur demurrage in 7 days, and you're going to pay all of it." Anyway, somehow that must have worked, because we leveraged the situation. And 3 days later, I demanded a Brinks truck with cash, which is allowed by the Uniform Commercial Code. But they instead gave us a joint check, and we're wondering if that was okay. I go, wow, this leverage works. So, we're in a time today, all of us, that we're in looking for an understanding of what kind of economy are we in, what kind of country do we live in, and what is this thing called rule of law, and how does it work? Well, in a nutshell, what I want to theme this seminar today in the respect for what we're all going through, to talk about the rule of law and really what mechanic liens give each one of you. And this is why I think it's very vital. It gives you, first of all, self-help, because what you're going to find today when we're talking, to get a mechanic's lien, you don't need to have any written agreements whatsoever. And the reason for that is because of the fact that in 1791, the first Mechanic Lien Act was created, which we're going to talk about in a little bit. Until today, we have 50 private lien statutes, 50 public bond statutes, and about 26 to 27 lien on fund statutes for public construction. And we also have a federal statute called the Miller Act. So I've had the ability, I was wondering when I was a young lawyer back at that first case that we took in on the Wisconsin Army base, how would my career develop and what would happen? Now I look back and we've had 9,000 cases, $3 billion of transaction, averaging $318,000 closed files. And then we've got another bunch of files that are open now that we're protecting clients on. So when I look backwards and forwards as to where we're at, I'm trying to remember what was really positive and where we need to go. So mechanical liens are statutory rights. And many of you may say, well, I feel that my accounts receivable are, and need a little help and a little thing. So one thing I'd like to ask you to also add in the chat, and I kind of want everybody to try to respond to this. And I guess Anatoly, you can take a look at that and add up a little survey, so to speak. How many of you believe you're a secured creditor when you extend credit to your customers? And how many of you believe you're unsecured? So if you can just put down, the answer, secured or unsecured, let's see what everybody comes up with. And then we're going to get the answer for that in a little bit. I'm already seeing some of it. It's kind of funny. This automatic like technology looking at the chat. Okay. All right. So let me stop looking at the chat and pay attention to our topic here today and show you how you can achieve ways to protect your receivable and self-help through the use of mechanical liens and other techniques that we're going to be talking about. So as we do that, let me start and share my screen.
Hal, can you quickly define secure versus unsecure? That's one of the questions that came up. I think it'll make it easier for people to answer the question.
I'd rather have them guess to start with, but I will in a minute. If you don't mind, answer the questions so we can see. And if you don't know, just say I don't know, because that'd be interesting too. But I will define that. Thank you, Anatoly. Let's see. Okay. All right. So as we proceed forward here, what we're going to be talking about today, specifically, and kind of answering your question, is an introduction to basically having a nationwide or single state lien system. We're going to define the mechanical lien laws. We're going to develop some tips for receivable management, how to get paid, and how you can become a secured creditor, and what some of the alternatives are. So the first thing you need to do in order to determine what your rights are is we have to understand the transaction. So the first thing we ask in any situation, and what you should be looking for, is in every project, in every contract, the NLB overview is how you prepare and save your data claim, your data sheet, and your claim form on the project. Then when you do that, that's going to be your step to securing your receivable. National Lien and Bond is a system of legal providers, so you know who we are. It was created in 1985 or 86 throughout the US, and we basically are one or two lawyers in every state, the top notice service providers in every state, and together we make up a team of providers that help you access some of the best people in the industry to protect your legal positions with lien and bond claims. So when you fill out, the way to start the process through our system is you fill out the claim data sheet and you fax it, or in this case, recently email with links, and then we would get back to you and help you set up your system, and then you can then take it over from there and maintain as much as possible, or as much help as you need. You can access the resources of the nationwide network of lawyers and notice services. So here's what a claim data sheet looks like, or project data sheet. Many of you, this is a little bit more complex because it's designed to be national than maybe what you're used to, but it has the information like who you are. Then it asks who your customer is, what's the project, who's the owner, GC, sub, what's your order situation, your status in the job, your documents, and who else is on the project down below. Of course, it has your contract, what state is it in, is the job private, public, or federal, and what's your first and last day of work. So once you have this information gathered, and this is the kind of information that you're probably today entering into your systems, and in doing that, you're getting all the information that you need. For us to understand together today what your legal rights are, the first thing we need to know is what state is your project in. The second thing we need to know is the project private, public, or federal? And the third thing we need is what is your relationship to the project? Once we have the answers to those questions, and you should be thinking about that every time you're selling a project, then we can understand what our rights are. So this is a little bit of closer information of what I just went over with you. It's pretty basic for those of you that have this. If you don't have it, we can help you establish a project data sheet. And today we're working on a new system that'll be coming out pretty soon. That will be basically allowing you to get everything online, and you'll be very impressed with the system. That's not quite ready to go, but it's on its way in the next couple of weeks. So in order to determine your rights, you have to say, can I lien a job? And in doing that, we have to first understand what's lienable. Like snow plowing, that's not lienable, that's maintenance, but asphalt paving would be lienable. Lienability is basically defined by your improvement to the property. So if you're supplying windows, if you're supplying concrete, you're supplying electrical, you're supplying fire protection, you're supplying HVAC, all the typical subcontract trades, it's lienable. If you're a construction manager, it may or may not be lienable, depending on the state law. So when you're looking at the law, we start, as I mentioned, you'll see the actual First Mechanics Lien Act, because I have a copy of it that I'm going to show you in a second. And it will be discussing who needs to serve a notice of lien and who does not. And we have to determine the amount of the lien. So let me just mention with the amount of the lien claim. People think that they can come and file a lien for whatever amount they want. Well, you're gonna know the first time you do that and file it in the correct way, that the lawyers out there love it when they're representing the general contractors and the owners, because they just attack those liens and they ask you to pay sanctions and have the lien removed. They claim slander of title and all these crazy defenses. So you don't want to be there. So the elements that we're going to be talking about today, about what is lienable and what you need to do to qualify for a lien, are very important step by step. And as long as you maintain the compliance, then the rule of law, which I'm going to be mentioning a few times today, it's used on the news media everywhere today, but I want to mention that as regards construction and how it relates to you as a business person. The rule of law, if you understand it, gives you the most important thing, the self-confidence to protect yourself and to really advocate your position. Okay, so please don't exaggerate liens or undervalue them. Sometimes what we do, for example, I mentioned to you, you have to improve the property. So what kind of things are not an improvement of property? Change orders would be, if they're still within the scope of your typical trades, but things like general conditions, which you're entitled to due to delay, that may not be lienable. So you've got to kind of look at those kind of areas and have somebody that's looking. You know, probably about a month ago, somebody filed a lien online with another, with an online service, and they found out that the person who their company name was I'm going to use a little different name, Violet Maintenance. And a Violet Maintenance organization, that was not a corporation. It was Jane Doe, who is the wife of the person that does the work, because she's a minority business, female business. And Jane Doe, as in a proprietor sense, not in a corporate sense, was the person. But they put down Violet Maintenance instead of Jane Doe doing business of Violet Maintenance. And the lawyer is attacking the lien right away, claiming that they're not licensed, they don't know the name, they don't have the permit and the right information, and so on. So again, you don't want to take shortcuts, and it seems easy, but the online service didn't review that. They just took the information and repeated it. Okay, so these elements have to be done. Now, something I want to just tell you, what have I learned in 40 years of practicing and representing people like each one of you? What I've learned is when you prepare yourself to do work on a job and you don't get paid, you want to have the attitude, if you don't pay me, I'm going to own your project, because the lien rights provide you that ability. If they don't pay you, you can go ahead and file the lien against the property. And we're gonna go over the steps in the element. So when we start with that kind of attitude, and even though you hardly ever get to that point in your careers, you've got to be ready to take those steps and be in that position, because that's, if they believe that and they look at you in the eye and you tell them that, that's going to give you a better negotiating position. And we'll have a couple of stories to talk about in a little bit. So when do judges consider a job complete? When is a job started? Those are important dates which are going to go forward. The case that I remember the most that gives an example of when a job is complete and not would be like, for example, if you're doing warranty work, that usually means you're not providing the scope of the work. You're coming in after completion. So what represents completion? For example, when you're done doing the work and you build 100%, which everybody does before they're done, or should be doing, at least in part, because you want to try to get as much of your cash flows going, because it takes you 30 or 60 days sometimes to go through a draw. So a lot of people who are smart subcontractors and suppliers generally bill it pretty much on time, but subcontractors need to advance themselves a little bit in anticipate of the cash flow that's going on to keep up, because it's always going to be a little bit slow. So if you show that you 100% build the work and you worked afterwards, you better be able to show a lot of payroll or materials coming into the job that's part of the original contract. Because if you don't, then and you try to extend the lien to a date that's really not when you completed the job for the contract, the warranty work, or you just came back for a little bit of work that really didn't make sense, because the judges will look at what date did you bill the contract in your bills? What date did you finish the work? So somebody installs a window, let's say in the fall. The winter comes like now, and they come back later on in the spring. What do they do in the spring? They put the handles on, the locks on, the hardware on. Okay, so the courts will look at that as being likely the completion was in the spring, not in the fall before, because the hardware is an instrumental part of the window system, for example. So when you're working on a job, knowing your first day of work and your last day of work, and sometimes each month you work, is important depending on what state you're in to understand it. Another thing that's important, and these are the necessary elements of a lien claim, is you have to have a contract. It usually should be in writing, but there's sometimes exceptions. You have to be able to perform the contract and complete the work and be able to say that you did it. Now, a lot of the elements, okay, have meaning, and the meaning has changed over time. For example, when you're performing a contract and you didn't finish your work, we're going to talk a little bit later about what you can do and when you can do it. The concept of stopping work and suspending work is something that I think is another tool that you have to understand a little bit about how to protect yourself and what to do. So we're going to get into that in a little while. And I want to make sure that you understand some of those things. So this gives you a quick summary of what time material would be lienable. Like, as an architect, construction lienable? Are the plans drawn? Are they accepted? Fixtures, are they attached to the building? Demolition, and so on. So,
Al, a quick question for you on that point as far as what's lienable. Lisa asked, would a cell tower be lienable?
Well, a cell tower is a telecom job, which is very much lienable. The cell tower lienability comes into, and I think, Lisa, what you're asking is, cell towers are usually not owned by like a telecom company, like an AT&T or Verizon. They're not owned by them. They don't own the land. A lot of times those cell tower companies actually lease the land. And so the question would be, yes, you would have lienability against the lease of the lease. Against the lien would be against the leasehold interest. It may or may not be against the owner's freehold interest. We just filed a few cell tower liens recently, and when we did it, we liened both the leasehold interest and we liened the fee interest as two separate liens. And the work in a cell tower is really no different than the work in any kind of project, because you're coming in and you're putting in the cell tower equipment, you're putting in the batteries, you're putting in if it's a regular cell tower, the steel, which is a structure, and then you're putting in all the technology. So I would answer that question, yes. Now, is Lisa a supplier or a subcontractor? Did she say?
Doesn't say here. Hopefully she'll chime in. But while we're waiting for that answer, there's another question that came in on this point also. And I know you have a lot of expertise in this. Are government agencies or municipalities lienable?
Okay. Well, we're going to get into that in a few minutes. The answer is you cannot lien and foreclose on property that's owned by a municipality under any circumstances. And we'll be talking a little bit about that, but let me just mention something that happened about 3 weeks ago. We were in the city of New York, and we liened the Brooklyn Navy Yard. Now, the Brooklyn Navy Yard in the 1940s and World War I and World War II was literally a military Navy Yard, just like Glenview Air Force Base was, and Gray Lakes is now in Chicago. So every one of us have military bases around us. But recently what's happened to a lot of the military bases is they've been sold and redeveloped, a lot of them during the base closure. So what's happened on those projects, like in the Brooklyn Navy Yard, it was deeded to the city of New York. Then the city of New York deeded it to a development company, and then that development company deeded each dock or developable site to a separate corporation. So we thought 3 weeks ago when we filed the lien in New York that we would put the true information. Who's the owner of the property? Well, the federal government deeded to the city of New York. So when we examined the title, it's the city of New York. But when we put city of New York as owner, the recorder of deeds refused to take it because they said you cannot lien, which they're correct actually, on the city property. We didn't want to argue with them because we can see that we have a form and they're looking at the form. So even though it's true the city of New York owns it, we put down the owner as the developers LLC as the tenant, because that's how the developer is taking title to the property. They can't take a deed. They have a long leasehold interest of 99 years. So they're the tenant from the development company that's part of the master development company that's a tenant to the city of New York. Okay, so we basically reverse the information. We show the owner as the LLC, who's the development company, as the leasehold interest tenant. So it gets a little confusing, but Lisa, that's a good question, because liening a leasehold is possible. A lot of people see that. We had another situation recently where a client actually the other day sold cabinets, millwork, and in the installation of cabinets and millwork, they did that in Illinois. The user was actually the tenant, and the owner of the property paid for everything because in his lease, he authorized the tenant to have a budgetary allowance. So when you have a lien on a leasehold interest versus a lien on a fee interest owned by the property owner without a tenant, which is typically what the situations are, you have different kinds of liens and they attach in different ways. So that kind of gets back to our situation that my general theme that I want you to think about. The rule of law protects you. You have to advocate your position, but you have to understand sometimes the complexities of the real estate title and the laws which online services cannot do, and they tell you that. And we try to provide the information expertise for you because we want you to have the information, because we have a lot of experience in the local providers of the lawyers and the lien notice services who actually have to do this. So when you see the ability to focus, and you see your people working for you from our providers of notice services, like I've been in, for example, in our group in Florida, Builders Notice Service is one of them, and in California, Construction Notice Services. What they basically do is they basically slave over the project data that you provided, and they verify everything, and then they go out and understand the difference between the various relationships, which we'll talk about a little bit here. So I kind of want to get into the little bit of history of where the Mechanic Lien Act started, because I think it's very apropos, because believe it or not, not only we're dealing today with the rule of law to provide you some comfort, but we're actually going back to the United States Constitution in 1787. So where the first Mechanic Lien Act came about was something to do with Alexander Hamilton and Madison and Jefferson and the founders of our country, because in 1787, before the first Congress of the United States got together, they went ahead and declared that the United States would be a republic with our institutions of government that we know today. And one of the things that they did not resolve back then, they left it open, which was smart because they got the Constitution passed. They created the concept of a federal city. Now, back to the question about, can you lien a city? What is a city? They basically created out of 10 square miles. The District of Columbia, which was not named in the first Constitution. They needed to have that meeting that compromise for dinner. If you saw the Hamilton play or you know a little bit about history, the South had an agricultural economy, which basically provided cash and very little debt, and they had a lot of assets and not a lot of debt at the time of the Revolution. The North, which was industrial, had a lot of debt in banking and finance and a lot of funding for the Revolution, and they had to figure out a way to pay for it. So the way they figured it out in the compromise that happened with Hamilton and Madison and others the night that they sat down for dinner was they ended up creating the agreement that the state's debt of all the states would be accepted by the federal government, and the federal government would pay for it out of taxes and revenues. And then the capital of the United States, though, would go from New York, and then went to Philly, and then ended up in Washington, D.C. So the southern states got the federal capital, and we all understand about what's going on recently. We've seen a lot of activity in the federal capital. So that was 10 square acres. That capital was owned, that property in the 10 square acres, by 12 families. They created a land trust of 12 families, and they gave the government half the lots that were plotted in Washington, D.C., where the government was going to be, and the private property owners kept the rest. And then the federal government built the streets and the improvements. And when they did that, nobody would go to work there because of the economic uncertainty of the debt and the bad economy that was going on. So in 1791, lo and behold, the first Mechanic Lien Act was created. And in that act, it was in the state of Maryland that donated property, in the state of Virginia, and it basically says, and I'm going to try to read this in this English, and for the encouragement of master builders to undertake a building and finishing holes within the said city by securing to them a just and efficient remedy for their advances and earnings, be enacted for that all sums due and owing on written contracts for the building in any hole in the said city, or the brickwork or carpenters or joiners work thereon, the undertakers or workmen employed by the person for the house shall have a lien on the house and the ground on which the frame, or the same, it's not frame, it's hard to read the Old English, the same is erected, as well as for the materials found by him, provided that said written contract shall have been acknowledged before one of the commissioners of the city, or justice of the peace, or alderman of the corporation of Georgetown, and recorded in the office for the clerk for recording deeds here, and created within 6 calendar months from the time and acknowledgement as aforesaid, and within 2 years after said work is done, proceeds in equity, which is a lawsuit. So here we are in 1791. So what is a mechanic's lien, and how does that help you? What are the steps for it? This is exactly the framework that's been followed since then, from 1791 till today in every state. It's a little bit different, and I'll explain this to you, because you have to understand the difference. In every state, the 2 steps that are mentioned here, which is recording the lien in the recorder of deeds and filing the lawsuit, that's within 6 months, and filing the lawsuit within 2 years, every state has the same steps, basically. But that is for the prime contractor. The prime contractor and you as a sub or supplier must take these 2 steps as well. The prime contractor only takes these 2 steps. We're going to learn in a second what steps you need to take in your state. So the two steps that everybody takes is recording a lien and suing. And when you sue in equity, which is chancery, because you're foreclosing on the property. So remember those two steps. You all have to take them. And now we're going to get into, this is on private or commercial construction, what the other steps are a little bit. Okay. So what wasn't done in 1791 that's done today, that's important, is if you don't have a contract with the owner, you still must go ahead and have a situation where basically, okay, you are serving, you're not in privity with the owner, you therefore must take a notice and provide that to the owner. So if you're a GC and you're an owner, you're in privity of contract, you're touching each other. So everybody who's, and all of you could be as a sub or supplier, all of you could be in privity with an owner, because sometimes owners act as their own developer, their own contractor. There's sometimes one entity, sometimes two, but you're in privity with the owner. So when you're in privity with the owner, he knows how much your contract is, as was mentioned here, has to be in writing, and the amount due, he knows that too. He or she knows that. The reason they know that, you're in communication, you're touching. Who doesn't know if you have a contract or not, or who should or shouldn't know? As long as you record for the right amount that's properly due, you don't exaggerate it, the law doesn't usually require you to have a notice. Now, in some states, you have notice of commencements now that have developed. In some states, you have other kinds of recordings. Some states require sworn statements to be provided by the GC, but you usually and typically, except for maybe sometimes to, let's say, a construction mortgagee or a tenant, as leasehold improvement, we have to notify the owner by a 20-day notice, like in California, in some states for leasehold improvements. And we have those states filtered out as to what those are. You generally don't have to do a notice. Now, if you're sub to a GC and you're a supplier to a GC or supplier to a sub, yes, the owner doesn't know who you are. And if you want him to pay twice and you want to foreclose his property and you want to go back to what I said, own his project and title and be in that position, then you're going to have to notify them on time. So there are basically three steps for typically subs and suppliers. 1, send a notice. 2, record your lien. 3, file your lawsuit. For GCs or primes, or when you're dealing in that capacity, 2 steps: record your lien and foreclose within the time period of the state. Now, not that this is any more complex, because I want to try to keep it simple. We have all the complexities you need, because I've been working for many years with the logic of the states and developing the software for a lot of programs people use and having software in this area. So what happens is, in the different states, there are different rules. So I don't know how many people are here today from Florida, but Florida's rules are you start providing your notice within 45 days from the first day of work, then you record your lien in 90 days, and you sue on your lien within 1 year, as I recall. But in Florida, if you send your notice by certified mail on the 44th day and it doesn't get there by the 45th day, that notice doesn't count. You have to send the notice by the 41st day in mail, or deliver it by the 45th day in person. So, it gets a little crazy, some of these rules. That's why I believe that the system that NLB set up 30 years ago is still the best system today, because the local providers of the information understand these differences and understand the ways and means. I've been doing this for 40 years. I've been everywhere around the country. I've coded the laws and worked with them. And believe me, I'm still learning every day what people do in their own state. And it's very complex in some ways if you have to know it all. But if you're in the state itself, people are very comfortable in what they do. So in other states, the notice would begin not from the first day of work, it would come from the last day of work. Like in New York, you have to file a lien within 8 months, and there really aren't any notices required. Just file your lien within 8 months or 4 months if it's residential. For example, Illinois, where I'm at, you file your lien within 4 months. If you're a sub, you have to serve it within 90 days. Except if it's a residential job, it's faster, it's 60 days. but 60 days from first day of work and 90 days from last day of work if it's commercial. And then these are the differences that are going on. Now in Florida, I mentioned the 45-day notice. In Florida, for example, because there's a lot of construction that goes on there, in that particular state, if you don't serve your notice within 45 days as a sub or supplier, you have no way to cure or remedy your lien. In California, you have 20 days from first day of work, and it relates back 20 days. And if you didn't do it right away, but you've been there for 4 months and you missed the first month, then you can also catch up on at least the last 20 days from when you finally do send your notice. So you've got to know some states are very strict and some states have a little bit more flexibility.
Al, quick question for you that was asked by one of the participants. Can you explain what it means to perfect the lien? They had recorded a lien, but later were informed the lien was not perfected within the correct time frame from end of project.
Yeah, so I think the word perfection basically means what are the steps you need to take? And again, we went through them a second ago, starting with the first act in 1791 until today. Record your lien. In that case, it was 6 months in 1791 and file in 2 years. And today it's by state. Do they know what state was that person in? Did they mention or not?
It wasn't mentioned, but hopefully
Okay.
they'll be able to chime in right now.
All right, so if they let us know the state, we can go take a look at it. But statutory here, you're going to find out how you become a secured creditor is 2 ways. Okay. Somebody asked, well, what is a secured creditor? How do I know if I'm a secured creditor? Okay. I can tell you right now, if you file your mechanic lien rights, you are a secured creditor by statute because you're going ahead, into this case, the example you just gave, Anatoly, if they would have gone ahead and followed the procedures of what was specifically required, they would then go ahead and have a lien against the property. And likely they could even in some cases prime the construction lender, and they would definitely prime other creditors of their customer because they would be able to get paid first out of the proceeds of that particular project. So even if the customer goes bankrupt, your lien would be not only against the land, but against the funds, and your contractor, who would be your customer, even if he files bankruptcy, you'd still be able to prevail over him because you extend the credit securely. If your liens aren't perfected, which means you didn't take all the steps in that order, then your lien would be defeated and it would be defended against and therefore deemed void. So the 3 steps are, if you're a sub or supplier, notice, record, sue, and do it within the time periods. And that's why I mentioned earlier, you need to know when is your first day of work for those states that require that, and what is your last day of work, and how the law incorporates the definition of those terms.
Quick question for you. You mentioned filing a lien not just against the building owner, but against other parties. There was a question from Gina. For a government building, can they file against the bond as opposed to against the building for a government job?
So when we get into government jobs, we're to get into, but let me answer the question. Yes, you do not have a lien. As I found out in the city of New York, you even put the city's name down on a lien because the recorders don't allow it against municipal jobs. But as I mentioned earlier, when I summarized, the first Mechanic Lien Act is now evolved into 50 private lien acts in all 50 states. The public jobs have 2 statutes that apply to construction. One is, as Gina's mentioned, the bond. It's called a payment bond. And the second, for the states, and for federal government, it's called the Miller Act, which is a payment bond. The states' bonds are commonly known as Little Miller Act liens. And if you go to the website, milleract.com or paymentbond.com, you'll come back to mechanicslien.com because we deal in all those situations every day. Now, the way the bonds work are different than liens. And bonds provide you protection. And there's 2 kinds of bonds. When you're a sub, or let's go to a GC, because many times a GC in a public job will get a contract. Let's call it a U.S. Post Office service, okay? And the federal government hires the GC and awards a contract. The GC is required to come up with 2 bonds: a performance bond to guarantee the government is qualified to finish the job, and a payment bond, which is with the performance bond automatically, that the general contractor will pay all of his suppliers or subs. If you're working in privity directly with the general contractor, you typically, this is true in federal law and mainly true in states, but somewhat different. You have 1 year to file suit against the prime contractor, and the surety within a year is responsible. If you're a sub or supplier, you have in federal law, typically the same, but not always in the states, within 90 days, you've got to give a notice. So the same rhythm of steps occur in public law that they do in private law. What are those? If you're working with the owner, in this case, the general, you sue within a year, no recording because you can't record. And then if you're a sub or supplier, you do your notices. So there's no recording in a public sense because you're not recording. So your first step would be file a lawsuit if you're working with the prime, typically within a year on public jobs, on a bond, and then send your notice if you're a sub or supplier within 90 days. Now, something that we're going to cover in a minute is not everybody has a lien or a bond. And I'll explain that to you in a second. You always have a lien if you're a GC against an owner. You always have a lien if you're a sub working the GC. Then it gets a little different, which we'll explain, the tiers. On federal jobs, a general contractor never has a lien on a public or private, on a federal or state or city public job. A general never has a lien. A sub always has a bond claim against a GC when the bond is issued, which is most of the time. And then a supplier or sub has a bond claim there. Now, something that I didn't mention, in addition to bond claims on federal, not federal, but state laws, on public construction, municipal and state, you have a lien on funds in 27 states, approximately. So the lien on funds is you file the lien against the schools or the library, the city, Department of Transportation, typically, capital development boards, and then that lien attaches not to the property because you can't have one, but attaches to the funds. How did I learn that lesson? Because I made the mistake, just as I almost did in New York with our lawyers there, but we corrected it, where we put the city of New York. They said, no, you can't record that private lien because even though it's owned by the city, you have to lien to leasehold interest, not naming the city. And then in my town in Chicago, Judge Segan called me to the bench, was a young lawyer, I don't know, 28 or 29. He goes, I see you've liened the Calumet City Police Station, Mr. Emilfarb. Is that correct? I go, yes, Your Honor. Why do you ask? He goes, are you a new lawyer? I go, yes, I've been out of law school for 18 months. Well, let me ask you a question. Do you want me to take your private lien and foreclose it and let all the people in jail out of jail? Is that what you're asking me to do, sir? I go, I don't think so, Your Honor. I think I just wanted them to pay the bill. How can you get them to pay the bill? He goes, then I suggest you go back to your office, release the lien before I hold you in contempt, because you've now filed a lien against the jail and the property of the city of Calumet, and tell your concrete contractor, supplier, that he's going to get paid if you file the lien against funds, because I've got a lot of Calumet City project claims here besides this one. And if you look at this section, the statute, section 23, the Mechanical Lien Act, I think you can go figure that out, okay? So he threw me out. He didn't hold me in contempt, thank God. I released the lien, filed the lien on funds, and here we are, I don't know, 37 years later, and summarizing all the states that have lien on public funds as well. Like New York has one, and other states. And those are very powerful. Yes, Anatoly. I think you're on mute. You're on mute.
Sorry about that. So two questions. One of them have to do with government jobs. If there is a franchise restaurant or something of the sort that's on the land of, let's say, an Air Force base, how do you execute the lien to actually get paid? Would you sue the owner directly, or what is the process there?
Well, typically the kind of properties that are there's two. Okay, when is federal or state or city or like a school district construction, and the agency awards the contract, the only process to collect would be when you have a bond or lien on funds, as I just mentioned. If, on the other hand, the public, which is happening quite a bit today, the public sector uses its property and leases it out for, let's say, for example, an airport, and in the airport you would have people that have leases and they sell restaurants, they sell food, they have the magazine places, they might have bars. Today they have, testing for COVID centers and things like that. If there's a lease, then your lien would be not against the property, but against the leasehold interest.
Got it.
That's what you
And
would
then
do.
the second question is for you. You mentioned that subs have different rights. So if you're working as a sub for a prime and it's on a municipality, do you have any rights to the material or labor installed as a sub, or is the lien only good from the sub to the prime? What if the prime goes out of business?
Okay, well, just like I mentioned, my stories as a young lawyer, and as we develop in our careers to where we're at today, is more seasoned, even though we learn things every day, is that, you know, bankruptcy law comes in. Now, bankruptcy law is the true, what I consider to be, referee of kind of like the World Wrestling Federation. They have a series called Survivor Series where 13 people get into a cage, okay, and one person comes out. And I can tell you that if you follow the procedures in the process to perfect your lien, as the other question was raised earlier, you're going to be able to take that lien on either a private or a public job or bond claim and enforce it against the bankruptcy. So in that particular situation, was that a public or private job that was mentioned, Anatoly? Yeah, you're mute.
Municipal.
Okay, so municipally speaking, it's kind of easy. So let me give you the hypothetical. Typically, what happens? So let's say the general contractor or a subcontractor files Chapter 11 or Chapter 7. Once that happens, everything is stayed, and you cannot file a lawsuit. But what you can do is still perfect this area of perfection, your steps to perfect your lien to make you a secured creditor. And then we get into bankruptcy. I'll explain in a second how the secured creditor status helps you. So the bankruptcy happens, let's say today, then tomorrow or the next day, you get the notice. And now you go, what do I do now? The first thing you need to do is make sure you take your steps of perfection, which are record the lien and send out the notices. Some states have a little problem with recording, but that's you can still do that. You just have to, typically you can send out your notices and record it. Those are not considered violations of the stay. They're called perfecting your steps as you're allowed to do by statute. And there's an exception in the bankruptcy law to allow you to continue to perfect your steps. Once you perfect your steps, your next step would be if the person you're going to be suing is the debtor, and sometimes you need to do that, is you make a motion to lift the stay and allow you to proceed to enforce your lien or your bond claim. Your bond claim, you may be able to proceed anyways because it's against a surety, but your lien on funds, you probably would have to name the debtor and ask for the stay to be lifted to allow you to have relief and proceed against the owner of the property if there's a lien on funds available in that state. Liens on funds are only available in about half the states, and the other half, all of them have bond claims. So it's actually easier to file a bond claim. I have a U.S. Corps of Army Engineer job right now that I've been working with, and the bonding company generally was pretty good. I think it was CNA in that particular job, and they worked it out with us and continue to work it out as we go along. So when you're working on federal, state, or municipal projects, yes, as soon as a bankruptcy hits, consult us or another knowledgeable legal group or lawyer that understands bankruptcy. We've had to, and I've had really the great honor and pleasure to represent suppliers, subs, and contractors in every particular environment. We have a situation right now, which is a little crazy. I'm not going to get into too much detail. Hopefully in a couple of weeks, you'll be able to read about it, where we represent a contractor out of Afghanistan, and we're suing the United States when the contractor went bankrupt. And he didn't have a lien. The judge got mad at me when I went to Washington last September. He goes, Mr. Himmelfarb, these judges are like asking me questions. Do you have a contract with the United States? I go, no, sir. Does the contractor have a bond? I go, no. He goes, why? I go, because it's in a war zone and they waived the bond requirement. And he goes, and did the GC go bankrupt? I go, yes. He goes, well, I'd like to hear about this one. Well, that's a topic for another discussion, but we figured out a way where we can claim remedies and rights outside of mechanic liens. But today we're here to talk about mechanic liens. And as I said, in a couple of weeks, that topic's coming to a head. And it may be something you guys will be reading about, hopefully on social media and some other things. Let me share my screen again. Okay.
And Hal, before you jump into that, I do have one more question here. From a drywall contractor that work on a county building and have done the notice to the owners and the bond company, what will be the first step in getting paid with the bond involved?
Well, if you've actually, make sure you've done not only your initial notice, you also have to do, like, I think that one might be in Florida, but I'm not sure. Okay, if it is, you did your 45-day notice, you've got another notice to do, and then you've got to file a lawsuit. So the first thing I would do is make sure all the notices are done, again, to perfect your steps correctly. And then secondly, we would just simply, if we were helping you with that, we would then go ahead and call somebody up that we know at the bonding company, and we would ask them to take the claim seriously, provide them the information. If they didn't pay it within a short period of time, then you'd file your lawsuit.
And this one specifically, the drywall contractor was in Florida. So I don't know if that changes anything.
No. Well, no, it changes. It doesn't change something. It just requires that all the perfection steps have to be taken, because we were asked other questions earlier. What does it mean to perfect? What does that mean to perfect the steps? What is the perfection process? It basically just means you read the statute, you read the law, you follow the steps. Florida requires in public and private jobs, I believe, a 45-day notice, as I recall from writing the software programs and being around Florida for, much of the 9,000 cases that we've been involved with. A good share of them have been in Florida. So out of those memories and recollection of Florida law, 45 days from first day of work, as I mentioned, and then you've got to serve a notice against the bonding company and against the general contractor, making a claim against the bond. And then the third step would be file the lawsuit. So we never, listen, nobody in their right mind ever really wants to file a lawsuit, but you have to look the contractor or the surety company in the eye, and they need to know that if they don't pay you, they're going to be sued, and they're going to pay, and they're going to spend a lot of money in doing that.
And well, first of all, as far as spending a lot of money, there's a question from David Clarkson also following up on that. Are the fees connected to perfecting the lien recoverable?
Sometimes they are. It depends on your contract and on state law. So, and we always ask for them anyways, because you want to be able to negotiate out a position.
Got it. And then one more question, last one from David Clarkson. I'll let you get back to your presentation. So he asked about, being the sub for a prime on a municipal job. So as a sub, my lien is against the prime, and my materials and labor expended is only recoverable from the prime?
No. Okay. So, I mean, I'm a little confused why we're separating out labor and material. What kind of trade is that? Do they say?
No.
What type of trade?
Didn't mention.
Well, let's say you're an electrician. We have labor and material, because a lot of times you may be bringing in material. You could be a window subcontractor as well. You're bringing in a lot of labor and material. So let's take a window erector as an example. So if this is a school job, we had one recently with the New York City School Authority. We've had them recently with the Maryland, Prince George County. Okay, and sometimes windows are supplied separately by the supplier to the GC. Sometimes they're supplied through the subcontractor. So if you're going ahead and erecting material and window and material and supplies together, all your money will be recoverable by the bond. For example, Maryland is a state, as all 50 states have them, where if you're doing public construction of a certain size, usually over $25,000 to $75,000. Sometimes smaller amounts aren't covered, but the larger amounts have to be covered by statute. Then in that situation, you have a position where you have recovery under the bond. So you file your lawsuit within a year, approximately, and make your claim within a shorter period of time, 90 days, against the bonding company, and you should recover all your money. There's nothing to do with the prime contractor whatsoever, because he's not paying you. You always have your contract action against the prime, but we always look at, if the prime's not paying, who's holding the money or who's got the money, and it would be the bonding company. Now, in New York, in Illinois, and other states, if it's a state that allows you to have a lien on funds, you file the lien on the funds and you file the bond claim, both. By the way, speaking of bonds, they're not limited to public projects. Payment bonds are also frequently available on private projects, commercial jobs, particularly in large residential. So architects and owners require their contractors to be bonded on many, many, many private construction jobs. So when you're looking at your rights and your remedies, you are protecting yourself by the statute, and you have protection on other instruments, such as a payment bond that may be out there that you're not aware of. If you look at our project data sheet, one thing that we want to make sure that you understand is it's again important to perfect your steps. You must have all the knowledge and information and understand how to manage it. Any help you need, we understand how, and we work with companies like yours to make sure you understand, or you sometimes outsource that information to us. So, I hope that answers the question. And if it doesn't, then, perhaps we can, talk later. So let's proceed ahead. I said to you before, even though you have these rights, you're not always covered. So let's look what happens here on a tier chart. So I mentioned this is a federal job as an example. It's a good one. If you're dealing with a prime contractor directly, then you're always covered. See how it says covered, covered, covered? Your supplier, sub, anybody dealing with the prime. Now the prime dealing with the federal agency, he doesn't have any rights other than to sue the government. So he cannot file a lien. Now a second tier person is covered when you're a supplier to a sub to a sub, and a sub to a sub typically. But a sub to a supplier is not covered in federal law. And neither would be a subcontractor, perhaps, that would be 3 tiers down. So if you look at the first tier, everybody's covered. If you look at the second tier, everyone's covered except for a supplier to supplier. And if you look at the third tier, subs to subs to subs would not be covered. Now, this is federal law. Now, unlike federal law, okay, unlike federal law, state law is a little different. In most states, a lot of states, and we have the states and the requirements of what needs to be done. Let me see if I can share that with you. Let me just double check something. Yeah, we have the list of the statutes we survey, which states allow everybody, like Illinois allows everybody, no matter what tier, to be covered under the under mechanic lien laws on private work and on public work. We had a situation which is really unusual, and it was covered both in private and public, where a precast plant received concrete off-site. So the precast plant, let's say, is located in Iowa, and the material supplier, the ready mix plant, delivers to Iowa. The precast panels are made in Iowa. They're shipped to Illinois, and then they're put into, let's say, a school or a building. So the supplier of concrete to the precast panel was covered because he claimed that was his material in the precast panels that ended up going to the job. So there's a supplier to a supplier, could be actually another supplier that was actually covered. New York, typically that's not allowed, only subcontractors or people selling subcontractors directly. But sometimes if you're an erector or a fabricator, you're now deemed not a supplier, but a specialty contractor. So, it's a little unusual to have these distinctions, but that's what these tier charts show. So most people are in the position of working with the prime contractor direct or working with a subcontractor. That's where most activity is. But as you start bleeding down and going to lower levels, you've got to understand if it's federal law, you're very restricted. The state laws on bonds also restrict you. So just because you're working on a federal job or a state job or a municipal job doesn't mean you're covered for the lien or the bond, or in the private sector, it doesn't mean you're covered. So you've got to be careful what your status is. So when you determine the amount of the lien claim, you have an original contract, change orders, back charges, someone mentioned legal fees, interest, and extras. So we look at all those things when we determine what is the amount going to be. We talked a little bit earlier about when do judges consider a job complete. So we don't need to talk again, but we do need to point out when you perfect your lien rights, you calculate your time periods based on the date of completion. these are the valid elements of a lien. Besides having your lien steps, part of the perfection process is understanding what are the elements of a lien claim. So you need a valid contract. Usually the contract is with your GC, if it's a sub, it's with the owner or a person knowingly permitted by the owner, like a tenant, to make the job. And then you furnish lienable materials, and then you perform your contract. Excuse me. So if you're not performing your contract, you're not entitled to get paid. And let me kind of tell you where that comes in. So I told you before we would be talking about, certain situations of when you can suspend work. Here's the problem that comes up. It's kind of like one of these problems where basically you find yourself in a situation, and I find it very difficult to tell you when and where we should be doing this. But when you're not performing, you're abandoning, unless you're justified to stop or suspend your performance. Thank goodness in most states today, there's actually statutes that say if you don't get paid within 30 days, you can then suspend your work. And if you're not paid 10 days thereafter, you can then terminate for the balance of the amount of money that you're owed. I would have a lot of problems when I'm talking to clients, because I became, like everything else, by accident, an expert in termination law. How did I become an expert? Well, one lawyer decided to write a treatise when I was like 37 years old on construction law. Well, I thought it was great because I'm an expert in lien law in all 50 states. And I thought he wanted me to write the lien law chapter. Oh, no. He wanted me to write, I found out later when I agreed to be part of the authors, the chapter on termination, modification, and extras. So I had to learn quickly over Christmas break that year, because there's a publication deadline, what kind of expertise was required on the area of construction performance. So what we don't want to get, that whole topic of termination, extras, and modifications is a seminar by itself. But I want you to understand one thing. When you are not getting paid, you have to make a decision. Do I continue or do I suspend my performance? You must decide that. That's not an easy decision. If you make the right decision and you get out of a mess, you're thankful. If you make the wrong decision, someone replaces you and they backcharge you and come after you for all the money. So you've got to be careful. We're not going to get into that today in great detail, because here we're talking about basically receivable management, but those issues do come up. And I'm going to show you some ways that you can protect yourself a little bit practically in a minute, some of the tools that help protect your contract and therefore your receivables. So when you're having a contract, one of the provisions that I think you have to keep in every subcontract or even material supply contract is that people like to default people, and there's different ways of defaulting. So in doing that, I like to have a provision in every contract I've ever been in that says, upon default by any party to the other party, both parties agree that the party allegedly in default has an opportunity to cure. That requirement is also allowed before you can file a lawsuit in many state statutes for construction defect cases. So we're talking here basically about what you can do for your contract. I would say, and you'll see this in an example contract, which I'm going to show you in a minute, that you should basically be in a situation where you can have an opportunity to cure a default, or if you put someone else in default, you want an opportunity for them to cure as well. Because you really don't want to get involved in litigation and fighting about who's right or wrong. And this is another, it's kind of funny because, again, I'm looking backwards now, but back then I was looking forward. I had represented a general contractor. He goes, my sub is not performing. He goes, what am I going to go do? Okay. So when that happened, I said, well, of course, he's in breach. You defaulted him. You cancel his contract and you go after him. He goes, how long have you been practicing? I go, why do you ask? So what he said was, and I believe this was, when you terminate a contract, you can do it by default or you can do it by agreement. But the first thing you better do is sit down with your subcontractor. If you're a sub having a problem with a GC, please sit down with them. Because when you sit down with them, you learn about what the problems are and what everybody's relative position is. And if you have the opportunity to cure provision in your contract, you get it resolved. And termination is a terrible step to take, and you want to avoid it at all costs. On the other hand, sometimes if you don't terminate and the contractor's not paying you, I've had clients recently, I don't know why, it must be in the water on the East Coast a little bit, but they're working since this is now February. They've been working since last November and not getting paid. Some people since June and July. When I get involved in the case, I don't allow that anymore, because I found out that these subs that allow themselves to be abused like that are doing it in a way that they got to be very careful, because these general contractors particularly are creating problems where none exist. And they're exaggerating the problem to such an extent that they take advantage of you, particularly in the large commercial jobs. So you've got to be very careful on how to handle this. And at the same time, you've got to be firm. And thank goodness you have prompt payment laws in many states. The overlay of laws in the states, besides mechanic liens, quickly are trust fund laws, prompt payment laws. You have time periods for which payment has to be made. You have contingent payment clauses that are basically prohibited in many states. So you have to look at these other provisions and see what kind of opportunities there are for you to have your rights and understand your rights, and have the rule of law give you the opportunity to look your customer who's taken advantage of you, likely in the situation, or thinking that you've done something wrong, and look at him or her in the eyes and explain to them what your position is, so they know that if they're not going to pay you, you're going to come after them in a way and take the steps to perfect. So you are going to own the property, and they're not going to be in such a good position at that point if you can do it. There's some things that are mitigating against problems, and I'm not trying to encourage litigation. I just want to make sure that you follow the rule of law, look at the statutes that are available to you, look at the contract provisions that we're going to talk about in a second, how to become a secured creditor, and be able to take advantage of your hard work and get paid. Now, let's see. Okay, these are the states which we call the hot state sheets, which on private laws require preliminary notice. So take a look at them and see if your state that you work in are any of these states. And if you need this information, when the seminar is over with, you can find the information on mechanicsync.com. And if you have any questions, you can just call us and ask for a free consultation, because our notice services and lawyers around the country are ready to provide the information to you to make sure you do protect yourself. Here are some other states where notices are required in the private sector. These are the states that require them in the public sector. And usually these are the notices that are required within 20 to 30, 45 days from the beginning of work. And these are some of the requirements of the states with liens against bonds that you have to go ahead and do the preliminary information. So what I want you to know here is somebody asked the question at the beginning, I think, Anatoly, what does it mean to become a secured creditor, and how does it become? Let me just take a look for 1 second at the, So we have secured, unsecured, defined secured, unsecured, unsecured. Yeah, okay. So
unsecured is definitely the favorite.
Yeah. Okay. And I think that's a misconception. That's a misconception, because it's my belief, but I think we need to do more than what I believe for the last 40 years, which I'll explain in a second. And that's kind of a little bit more of a different topic. But I believe that every one of you in every state on a private and public job would be secured by a lien against the property, a lien against the construction loan funds in some states. Effectively, it's the same thing, because we lien the property tied to the lender. And then on public jobs, a lien against the funds in those 25 or 26 states that have that statute. And all of you are protected on private and public jobs when there's a bond. On all public jobs over 25 or 50 or 75,000, depending on your state, or it's federal or state construction or municipal, those bonds protect you as long as you're covered within the right coverage. As I showed you on a federal job, suppliers to a supplier is not covered when they're working like when there's a prime contractor and a supplier. So a sub to a sub to a sub, that sub may not be covered. So other states and other bonds that are issued sometimes allow for all parties delivering any materials to a job. So it's a wide range of who's covered by the definition of the bond or the definition of the statute. And then I'm going to leave you with one thought that I want you to think about, because there's something that's really looking forward, not backwards. I have a question. I'm wondering if anybody has done anything here with this, but there's going to be important steps that I think we need to take besides what we just went through, which I'll leave with you because we're kind of contemplating putting that together. So for you to have a great receivable management program, and for you to have a 30, 60, 90 cash flow, to have all of your receivables, which are your probably most important asset or one of them in your company, you want to develop a great receivable management program. And in doing that, you want to become a secured creditor, which by perfecting your liens and following the steps and verifying upfront if you're covered as a supplier or a subcontractor or a lessor of equipment, let's say, or you're providing some sort of other type of service that you want to make sure you're covered for, you want to be able to then be positioned to convert yourself from unsecured creditor to become a secured creditor status. That's your goal. How do I convert myself from being unsecured? Now, one thing about being unsecured, you could be eligible for security, but as that person talked about before, their lien was not perfected, and therefore they were not able to follow the process and be able to do that. They had the right to be secured, but they ended up not being secured because of steps that they did not take.
Al, to close out, there are a few Q&A questions I wanted to touch on as we.
All right, let me finish right here, and then we'll get to those right away. All right.
Mhm.
So, in order for you to exercise the rule of law and exercise your rights, you have to provide, like exercise at home, daily procedures for conforming to lien protection. You have to look at, and we have concepts of reviewing how to review your agent account report and how it fits into these time periods. You look for audit procedures for monitoring lien time periods, and we have the deadlines to help you understand the various situations you're in and where lien rights begin and end. So, you know, when we do that, there are other alternatives, and this is what I want to talk about for 1 second, and then Anatoly will go to the questions and answers. So, even if you don't have a lien, don't give up. Somebody called me the other day. It's kind of funny. They may be on the show today, so on the webinar, so I don't want to give it away. But they filled out one of our project data sheets and asked for help, and by mistake, instead of writing back, I think to our client, we send an email to the owner of the property and said, hey, well, this is what it takes to lien this job or something like that, and so on. And my client who came to us for help had been trying to get hold of this particular person for a couple of weeks. The guys wouldn't return the call. I don't know, 3 hours later, or the next day, funds were wired back to them. I wish it was that easy, but that's what happened. So even if they don't have lien rights or you haven't exercised your lien rights, sometimes, you know, just by communicating and getting us involved, or if you aren't making progress, that helps. What are the things we would talk to that person about? Sign a note, sign a contract with a judgment, guarantees. We can attach to your property. We can make claims against bond. We can sue the lender for diverting funds or something. Unjust enrichment, asking for joint checks, trust fund, prompt payment, and retainage laws. So, you know, we don't talk about all these things when we're talking to a GC or a developer who's not paying, but we know them in the back of our head. We're looking for them, and we want them to know when we look them in the eye that if they don't pay you, we're going to own the project if we can, and they're not. Now, if we don't have lien rights directly, I do want to share something else with you. Hold on 1 second, because I want you to see this. So these are some of the risks that we're going to be talking about the rest of this year as we have monthly seminars. How we obtain evidence of financial assurances before you go to work. How we ask owners and GCs to work with us as suppliers and subs to team together to work on joint checks. Why would a subcontractor want a supplier to get a joint check? Why not? He owes a supplier the money and it gets the cash flow. And the supplier, who's your good friend anyways, usually that you use on many jobs, okay, can go ahead and be the person asking for the money and find out what's going on in the job. So bonds exist, and when they do exist, you can't take certain steps, or you might let the surety have a defense, such as if all of a sudden you have a lien, you give it up, and the job is also bonded, the bonding company may say, well, you've released your lien, therefore you've released your bond rights. You got to be careful about that. You've got to be careful about what kind of dispute resolution clauses are in your contract, mediation, arbitration, and so on. There's a new thing called med-arb, mediation and arbitration, which is again another topic, but something to consider. Some contracts have no damage for delay clauses you have to be on the alert for, pay if paid clauses, pass-through claims. We just had one that we're settling today. It took us a long time to get paid by the federal government in Chicago on a Corps of Engineer job. We have a great New York office that we work with every day, and they do federal government contract work. And what happened there was a storm occurred on October 31st, Halloween Day in 2015 or 14, and the whole work that our contractor and excavator did washed away. They said, that's your risk. We then went ahead and we were fighting with the U.S. Corps and the prime contractor who did file business, and therefore the bonding company. And they said, you didn't do this work. You didn't do all this extra work, and we're not entitled to any storm damage. So we found an article online, Channel 11, the public policy station, where the reporter came down and showed after the storm, our client on videotape for 45 minutes on the tapes that we subpoenaed from the public workstation. And then we saw all the work being done. And then the next day, they did an expose in the paper where the architect and the U.S. Corps got into a disagreement, because the architect said you need a barrier island in front of this island in order to do this construction, or you can endanger yourself by having washaways, which happened. When we found that out, we weren't going to collect on the fact that we did the work we should be paid because the storm came. We had to collect on the basis that the government is liable when they put out defective specifications for the value of the defective specifications. So we took a claim by the GC and sued the government, and we just settled that last week. Then there's timing clauses in your contract you have to be concerned about. Termination, we talked a little bit about today, and damages. So those are things you have to be aware of. And the other thing that I just want to show you, and we'll get to the questions, is that in all your subcontracts and your credit applications, you have to be careful. They have to be reviewed periodically, and we're kind of updating them all right now. So you want to be able to list your contract documents, only make sure that you're limiting your obligations, not to everything, but the scope of the work in your bid and proposal, that you strike from any documents terms that don't apply to you, that you attach, which I'm about to show you, a boilerplate contract. And so a lot of times the contractor will not take the boilerplate, but he'll allow you to edit his form. I'd like to know, because we always have really great people that are attending these programs, how many of you feel you have a good expertise and what contract provisions that you like to edit, and how do you edit them, and what is your practice? That's not something for right now, but I would love to hear from you on that. Here is a rider that basically says, if you take any rights of my way away to give up liens, we take exception to that and say any provision in your contract that says that basically is disallowed. Anytime you try to show that my contract doesn't control over, that you're requiring other contract terms such as master specifications or project manuals, it doesn't apply unless you list them. Any contract that says that the sub waives damages for delay or otherwise interferes with our work, we don't accept those provisions. So we basically take the risk we just saw before, and we just say any provision that limits our ability to cure any defective work, okay, for example, would not be enforceable. So there's a bunch of provisions that we go back. These are called ways that we counter the general contractor's boilerplate. Because it's easy just to go ahead and give them a rider and see what they say. And then if you have to, they don't accept your rider, then you go ahead and look at the provisions of the subcontract and start that discussion to go from there. Okay, Anatoly, we have questions?
Yes, we got a few. So one is from Eleanor for New York State. I received a demand for an itemization of the lien amount. My client's case is based on progress contract. So there was a balance due on the contract plus balance owing on COs. The total was the lien amount. The owners were notified of the balance due and refused to pay, so a lien was filed. How can that be itemized? You purchase what you need for the end of the project early on. Also, projects don't go into in order of the scope of work. This is a private job.
Well, I'm not exactly sure exactly what the question is, but there's a step in New York that allows a lien claimant, and I believe she's a lien claimant, I'm not sure, I think she is in that situation, to go ahead and request from the owner, lender, an itemized statement. And in that itemized statement, they have to say how much money has been paid to the general on behalf of the sub's work. And then that should provide you information. If you can't get it voluntarily, you can then get it by a court order.
So I think she actually received the demand for itemization on
Well, then
itemize
if
their
a lien
claim.
claim, then if she's an owner or a GC, let's say, and she receives an itemized statement request from a lien claimant, that's who's going to file that, then you have to respond back in accordance with New York law and give the details, that would again explain to the lien claimant whether or not she as the owner is holding the money, or she's the owner, or if the GC is holding the money, or the G paid the sub, whether the sub's holding the money. Because under New York law, you think, for example, you have a really opportunity not to do anything because it's an 8-month requirement to file a lien and 1 year to file your lawsuit. You can renew your liens in New York. People often do that. They don't sue necessarily after the first year. A lot of renewal goes on, but you're waiting 8 months to file a lien. You think that's a good idea? Well, guess what? It's only a good idea if the owner hasn't paid the general, or the general hasn't paid the sub, or somebody hasn't paid the customer above you. But if they paid them, then they're released because you didn't file the lien while there was still money left on the job owing to your customer or to the sub or to the prime contractor. So you don't have 8 months. You have to file your lien right away and make sure you capture the money before it gets paid out and release the owner from double payment. Now I'm working on a case in Delaware right now, today. And in that case, it appears that if the owner paid, which he did, it's a window job, the window installer and the supplier comes in and doesn't get paid, then that supplier probably is going to force the owner to pay twice, I believe, in Delaware. I haven't confirmed it exactly, but when we look at the statute today, we're waiting for our Delaware office to confirm it. That's what it says. So even though you have time, if you sit on your rights and you don't exercise them, and you don't look at the rule of law as a good credit and collection and tool to protect you, and you ignore your rights, you're going to find out that by not taking the steps timely, you're going to be out of luck if something goes wrong.
And as far as timing, there's a follow-up question also from Eleanor. What about if the owner locks you out so you can't finish, or worse, in their case, the owner disappeared and did not respond to bills, emails, phone calls, etc., and then appeared over a year later saying that the GC breached?
Okay, so I mean, basically, if you're locked out and you don't exercise your rights, you don't have any more rights against the owner. Now, New York does have, one of the remedies in New York is a trust fund law. So it's usually, I believe, 1 year from the last day of your work on the job to exercise it. So that's, again, an example. You have rights, but if you don't exercise them, they're not going to benefit you. But, a lot of times people in those situations require people to intervene and sit down. And I wouldn't say ignore that the time periods have gone, but there are contract rights and people do have conversations. So a good idea would be, let's quit pointing fingers and find out what really went on and bring everybody into one room. Yeah.
Perfect. Just a few more questions. One from Debbie Clarkson. What do you do when they bond around your bond claim?
Well, you can't bond around the bond claim. You can bond around the lien. but a bond's always going to be in place if it's a bond. So usually what happens is when someone files a lien, and this has been a big problem lately, that they're discharging the lien, and in doing that, they're replacing the lien with a bond claim. As lawyers, we kind of like that because it's no longer require us to foreclose and bring in multiple parties in. We just go against the bond, and it's a much cleaner remedy. But it does create today a problem because it generates litigation. Because they're taking the money that's owed to you. Let's say it's $100,000, and you filed a lien. Normally, people don't want to lien on their property for $100,000. I mean, we have a lien claim. We're in a case right now in New York City. It's $100 million. It could be a couple thousand. People don't like liens on their property, so they will be more incentivized to resolve the lien, like what was going on in New York just now, but that they didn't do if the lien was on the property. But if the bond comes in and discharges the lien, there's no incentive for them to do it because now the risk has gone to the bonding company, and whether it's the owner of the bond of the lien or the general or a sub, whoever is going against the bond now is forced to file suit. And that's not something that you want to be in a position. There are ways to try to negotiate around that, but the minute somebody does that, you probably should file suit immediately.
Got it. Thank you for that. Next one, as a subcontractor, if the property owner is different from the GC, do they have to send preliminary notice to both parties?
Well, usually the notice requirements are different by state, but it's good practice, even if not required, to notify the owner, the lender, the tenant if it's tenant work, whoever people are there, as well as the GC. Everybody should be notified in any event. And some statutes don't require copies to go to everybody, but they always go to the owner, and they typically go to the GC. And sometimes states require them to go to construction lenders.
And this one specifically was in Washington State. I'm not sure if you have.
Yeah, I don't have that off the top of my head at the moment. But we can, quickly find that out.
Got it. Okay. And the next one also same thing. It's a state specific question. So I'm not sure you'll be able to answer it, or if they should reach out for further information. But can you still file a lien for a private job in California after the 90 days?
Well, okay. Usually California, again, I've written the steps of the process and litigated in California. We have a trial coming up on a big project with a big contractor in a couple of weeks. So in California, you serve a 20-day notice. When you serve the 20-day notice, the owner gets it, and he's now on notice that you're around. Then in California, I believe you have 90 days from the end of the project, not the end of the day you work. And when you do the lien that you're going to file, why would you wait more than 90 days from when you're done working, even though the job is continuing on? We had a situation like this recently where a mason contractor came to us on a couple $100,000 lien, and he didn't ask. And when we looked up the project that was done, it wasn't just an ordinary project, it was a condo. So not only did you have a problem on one job, you had 125 condos, 75 of which have been sold already. So the job has been done more than 90 days before. And you also know that that is way beyond, because the mason contractor is one of the early trades in, way beyond 90 days from the mason contractor. So you have 90 days to file when the project is over, but if the owner or the contractor file a notice of completion, that shortens the time period to 30 days from the day the notice of completion is recorded. So you've got to be careful in California that you really, just like the job in New York, don't get lulled to sleep thinking that you got 90 days from the job is over, and then you find out later that you have all these other obstacles that come in your way. So, if somebody owes you money for 90 days or 75 days, you better jump on it. And if you send the notice of commencement out, notice of furnishing out in California, then that owner has an obligation to send you a copy of the notice of completion that it records, which shortens the time period to 30 days. It gets a little crazy, but if you're in California, you should be used to these kind of things, because California requires licenses, and contractors and suppliers kind of know that from dealing with it out there. But if you're not from California, and one of the things National Lien and Bond does very well is we help manage your receivables nationwide. As you can see, it's quite a task complexities that are going on, and people try to simplify the complicated. Sometimes it is a simple answer. Sometimes it's very complicated.
Got it. Thank you for that. Next question is, does a mechanic's lien apply to a service call?
Typically not, but it depends on what's being done. Like if a hot water heater was put in, as a service call, that probably would qualify. But if you came in and repaired the hot water heater, it probably would not.
Got it. That's interesting. Next one is, in Florida, must a permit be filed in order to give you lien rights? If a homeowner refuses to sign a permit application, are my lien rights prohibited?
Florida has something called a notice of commencement that's usually recorded. And on the permit application, as I recall, the notice of commencement is referenced as to the questionnaires point. I'd have to double check and see. But read me that question one more time until I want to make sure I understand it.
In Florida, must a permit be filed in order to give you lien rights? If a homeowner refuses to sign a permit application, are my lien rights prohibited?
Well, I think that comes down to, in all states, if you work on a job that should have been permitted and you don't get a permit, I think that's the question, then you're taking a risk. Sometimes you can cure it, and sometimes it does not affect your rights. But it just depends on the specific facts and applications, because it depends on the degree of what the work was being done. If somebody comes in and paints your house, I don't think you're going to require a permit. But if you come in and you put in a foundation in a house, you don't get a permit, I think you're going to have a little bit of a problem. You might be able to rectify it by getting a permit after the fact, or you may not. So I don't know the exact answer to that question. Perhaps we should reach out and I can talk to our office in Fort Lauderdale who does that every day. But I would say that you've got to be very careful in any state, and in particular Florida is a very strict state because of the licensing laws and regulations, because of hurricanes and other things. Construction is very heavily regulated. Like in Illinois, only roofers and plumbers and electricians require licenses, as I recall, but most of the rest of the trades don't. But California, if you're not licensed and you do work without a license, which is another similar question to what is being asked, or without a permit, you're going to definitely have a problem. Sometimes you've been paid. Under those state laws, you might even have to pay the money back. So, legal compliance and the steps. Don't get yourself into trouble by working on a job that you know should be permitted, or working on a job that you know you should have a license for and not doing it, because you're going to get into trouble and it's going to cost you a lot more grief later on. You find to take a deep breath, follow the steps. If you need help, call us, because we'll definitely get involved and advocate for you.
A couple of New York specific questions. So in the state of New York, do you have a year from the date of the lien or from the date of your last day on the job or finish date in order to file your lawsuit?
Well, let me repeat my understanding of New York law. And one thing I want to make sure everybody understands, I would say this is all subject to my office in every state. But in New York, you have 8 months from last day of work as part of the job completion, your last day of work, and to file the lien. That'd be done on a commercial job. Residentially, it's 4 months, and once you file a lien, you file a lawsuit, as I recall, within 1 year of your last day of work. Again, these are educational hypothetical questions, but generally speaking, that's correct. Most people in New York, when the lien time period comes up in a year to renew the lien or sue, they usually renew the lien in New York. Typically, that's a practice. New Yorkers take a little longer to do things. I don't know why.
Normally they're faster. So another question from Eleanor, also in New York. There are two different legal rights in New York. The foreclosure right is within the duration of the lien, but contract rights, meaning those causes of action under contract, you have the SOL for contract in your state. In New York, I believe it's 6 years. Hal, maybe you can confirm.
Well, I would say it's a really good question. So every remedy has its own statute of limitations. The lien laws are usually pretty short as compared to most statutes. The contract laws, if they're oral, are shorter than if they're in writing. Like in Illinois, it's 5 years if it's oral, 10 years in writing. I don't know the exact time period to file in New York, but 6 years could be correct. We looked at Upper Call our office, who's upstate in New York, and those we would know the answer. But yes, every remedy, which are called separate causes of action in the lawsuit. So the lawsuits that I've seen in New York when they're getting prepared would be first breach of contract to the question that was raised. The second one would be mechanic lien foreclosure, presuming you're filing within a year. The third one would be against a bond claim if it's a private or public job, and then that has a bond. And the fourth one would be for a trust fund violation, for violating the trust fund laws in the state of New York. Then there possibly could be other ones called unjust enrichment and quantum meruit. Sometimes they're allowed and sometimes they're not, depending on the facts.
Got it. Thank you for that. Next one is from David Clarkson. What is the least amount where it doesn't make sense to file a lien?
You just have to have somebody that's going to care about you and try to take steps. We have the other day, everybody in our group decided not to take on a lien. They were like, I'm not going to say which kind of owner it was specifically, because I don't really talk necessarily about people's claims as they're my clients without their permission, and even then we don't talk about it. But this was about like a convenience store and a gas station, and they were all around the southern states of the United States, and the contractor was owed roughly $30,000, and they went and worked for a company who managed the convenience stores, and one of its construction manager customers who managed the construction, and every store was 3, 4, 5,000. So nobody would take the claim on. We decided, it's not really fair that a person goes to work, does all that work, 3, 4,000, 500, 200, 300 on all these stores. So we leaned a bunch of them, not all of them. And I think they got the message. We're trying to get that resolved last week and this week. We'll see if we're able to do that. And hopefully we'll be able to do it. And then, we look at that as 30,000, not 500 or 300 or 200 altogether. So, the whole concept is really a question of fairness. Now, the owner representative came back and said, we don't owe this person anything. I said, that may very well be. All I need is a copy of a canceled check in the detail of the work that they didn't do. For example, going to a convenience store and a gas station, our client did ceiling tile work. Can you show me the ceiling tile work? Who else did that? Our client did some countertop work. Can you show me that you paid somebody for countertop? You're showing me electrical and plumbing work. We didn't do that. What are you talking about? Okay. So, it's like, I don't know, we have a passion. I don't know why, but we have a passion. So we've had the name since 1999, mechanicsLien.com. And all I can tell you is, if you go on the website, we have over 9,000 jobs that are completed, $3 billion worth of work, averaging 318,000, which means some are 100 million or 50 million or 10 million, and some are 3,500 and whatever. So, it's not that we can afford to take everyone on and sue for everything, but we definitely want to make sure we at least make a good effort so we can look our customer in the eye and say, if you don't pay me, we're gonna protect ourselves by the lien or other legal means possible. And then we have to look at ourselves and say in the mirror, okay, did we do a good job, and are we able to help people get paid?
Got it. Next one, which you got a few more, and I think we'll close it up. But can a lien help with change order payment? With change orders, payments end up being reviewed at the end of the job in California.
Well, California's not the only place the change orders get reviewed, and sometimes you get back charged, even though if you read the change order, it allows you to collect. We have a situation right now where one of my clients is skiing. I don't know exactly what mountain he's on. I'm guessing Colorado, something Anatoly you'd be familiar with. But what happened there was we were back charged. It was like a $700,000 owed to one of our mechanical related trades. And the GC, who was also the developer in part, hit us for like a $600,000 back charge, saying we were late. And this is in Florida, we were going through the change order, and lo and behold, as lawyers, we said to our client, if you look at change orders X number X and Y, they extended the dates by like 75 days or something. And those are the same days they're asking you for back charges due to delay. Has anybody realized that the general contractor and you have already signed off on the schedule, and we're going forward. So even when we had a change order with the days going, okay, specifically in there, countering the claim of the vice president, who I guess made up the claim. He just invented it, okay, the back charge, because his document stated otherwise. Yes, we leaned a job, and we're hoping that that's going to resolve itself. Imagine if you're dealing with someone's commercial paper or activity, that they would back charge you for the very thing that the change order says you did correctly. I mean, they just, I mean, it's unbelievable what I see happening today. You know, the spooks are out, I guess.
Is there a lien form in each state, or is it just one form and then you guys do fill in information specific for each state?
Well, we have, I showed you earlier the project data sheet, which is the form that we use. We're kind of working to make that a little bit more simpler. Because like, for example, when we send notices out, typically in California or Florida or Georgia somewhere, you don't need all that information. So if you're doing a notice, we're working to getting a short form of what information is necessary. But, you know, for us to review something, because we look at things a little bit differently, because we look at everything to go right and everything to go wrong. So we look for the information. Like, for example, you can do a form and it may not ask the question, does the job have a payment on it? Now, on a public job, you can almost presume that it does, and we try to find it when it's out there. But on a private job, it may or may not be there. But if you don't ask the question, you don't add that kind of information in there, then you never find the answer, and therefore you don't know what other rights you might have. So the answer is, we have a form, it's online, that we're developing. I showed you before a PDF that's been fillable, and pretty soon it'll be probably adaptable by state. Right now, it's still centralized for all 50 states.
Got it. And then last question, before I even ask, Carrie came in a little bit late. She messed up with the time zones. Yes, we'll be sending a follow-up to this with the presentation, as well as an invitation to the next one. And then a question from Amy: in the state of Florida drywall sub, when talking about when the lien right expiration, thus competing a decorative portion of the scope original contract still count as your scope not being completed and extend your rights?
Say it one more time.
So they had the core work and then they had decorative work that they had to come back and do. Does that decorative work extend the rights on when the job was actually completed, or is it when the core work was completed?
Oh, I see the question. Okay. So the answer is we started this discussion earlier today. We defined date of completion, you know, with the window and the window accessories, latches and handles. Same kind of question. When your work is done in the contract for which you're leaning, then you must use the first day each month that you're working and week, and then the last day. If it turns out that this is a change order that relates back to the earlier drywall, usually drywallers and painters are sometimes one of the same, because it's commonly done that way, and the contracts could be separate, or they could be joined. So we'd have to look at the contract to double check and make sure, because this is in Florida. Florida is very strict. If you file the wrong amount, or which would be if you're complete with your drywall work, which you have to be, and you're not, and you should have been paid for that before you paint, but it may or may not happen. And then you go and do the paint work, then that could be a separate contract, or it could be the same contract. But you may not have, because you have one scope of drywall and paint. You may not have done 2 notices. You might have only done 1, and out of the 45-day notices, they're very strict. So you've got to kind of really look at the facts there to go analyze that. But that's a good question, because when you come back in and do the decoration work, you should say, and as an extra to my contract for which I started, I'm now going to do this work here. So if you haven't gotten into a fight with the person, you know, I mean, you may want to add that on, unless you've done 2 separate notices, or it's really 1 contract.
It's not a change order. It is part of the core contract.
Yeah, if it's part of the core contract, then you should be fine.
Got it. Well, with that, we wrap up. Sorry we ran a little bit late, but had some great questions. Thank you, everyone, for attending. We are going to be sending a follow-up email with the PowerPoint presentation, as well as calendar events for future ones. And Hal, thank you so much for sharing all this.
Thank you for spending the day with us, and everybody good luck, and be passionate and follow the rule of law. and you'll get paid.
Thank you.